just a couple of house rules before we sort of, start with the webinar. If there are any questions, if there are any doubts, please use the Q&A box. The Q&A box is given there. Like, use it for any questions that you might have for Aditya. He will answer those questions there. I will be moderating the session, so we will be able to track the questions better if they are there on the Q&A box. If we have any questions for you, if we want to know anything from you, please type your answers in the chat box, not the Q&A box, so that so just to be clear again, please use the Q&A box in case you have any questions, and please use the chat box in case we ask you any questions and you have any comments or anything else that you want to share with us, or anything that you would like to tell us. So yeah, let's and just to sort of like I'm sure all of you might have seen the agenda on the Lawctopus page of the webinar, but in case you haven't, just to sort of give you a quick recap, we will be talking about content moderation and takedown today. We will be covering a lot of topics in it, and we will take questions towards the end of the webinar. In case there are some, we might take some questions in the middle too, but we will take most of them towards the end. Please be patient for your questions to be answered. We will definitely take up as many questions as we can, and we really want this session to be as interactive as possible. So please ask as many questions as you want to ask. We would love to answer them, and we will take them up, don't worry. And we have a surprise waiting for you towards the end of the session. So please stick around, don't leave till the end. There is a surprise waiting for you, for all those who stick around right till the very end. And yes, and I'll not take up much of your time. I will let Aditya do the talking. But like, just to sort of quickly recap again, please use the Q&A box for questions and use the chat box for anything that you might want to tell us. And I'm sorry, before like Aditya takes over, just to sort of get a very sort of idea about our learners here. We wanted to understand which year were you all in? Are you still in law school? Are you all practicing? So we just wanted to understand what level are all of you at, so that we can tone down the content or tone up the content accordingly. All right, so there is someone from the first semester LLM. Hello. Please use the chat box to let us know. Okay, there's someone in the second year, third semester. There's someone in LLM first sem practicing. Okay, we have a second year and a fourth year student. We have a second year student, a fifth year student. Okay, we have a law professor as well. Hello, ma'am. We have a first year student, a third year student. All right, we have a lot of law students and a couple of practitioners and professors in the midst of us, and that's great. That's really helpful. It will help us understand how to sort of deliver the content to you better and help you understand better. So, all right, thank you so much for typing this in. And yes, I think we'll begin now. Aditya, over to you. Thank you so much for.
Thank you for the very kind introduction, Shreyanshi, and and of course it's a very difficult time, and it's really amazing to see that so many people have joined this session, and they are sort of trying to actively ensure that they keep themselves updated on different areas of law. So it's very commendable. It's definitely not something I did so much in the law school career that I had, but it's quite amazing. And as I sort of work in the professional space now, so I realize the importance of this continuing education quite a bit. So it's quite great to see the amazing enthusiasm that you guys have. So I'll sort of not take up too much time, and I'll just sort of get into the session. Just let me know on the chat box if you guys are able to see the screen, or if you want me to make the screen a little bigger, just in case. I'll try to, yeah. Are you able to see the screen, Shreyanshi?
I can see the screen. Can everyone see the screen? Please reply on the chat box. Okay, it's visible.
Okay, great.
Thanks, guys.
Thank you. Yeah, so the topic that we are sort of covering today for today's webinar is content moderation and takedown. And so basically this topic is fairly, I mean, it's a up and coming topic. And if you are advising any search engine or I would say any social media platform or messaging platform, any kind of content creation platform, then you will essentially in your career as a lawyer definitely come across queries from the clients about how to address about how to deal with this topic and about how to sort of address these questions. So basically, just to start with the approach that I felt I should take for this webinar. So first of all, uh, this is only a 1 hour session, so it's not possible to exhaustively address each and every issue that is there in this space, and there is quite a bit of it. So what the approach that I am going to be taking is to essentially have this very first principle level approach. And I think because there is a diversity of learners who are attending this webinar, it might the idea here is to sort of try to tell you how to think about this area and the basic legal principles that apply in this area. And uh, I think that sort of is a good starting point for anyone who is sort of venturing out to figure more about this space. I'll also try to take up some real world case studies towards the end of the webinar to try to give you a flavor of the kind of queries that you get from clients about content takedown and moderation, and how could you sort of figure out a way to respond to those queries, because ultimately this is what makes a lot of difference when you interact with these clients, when you go and explain to them uh, how this entire space works. So one of the most fundamental things about information technology law, the way it is in India, is that the law is fairly archaic. The law was designed in 2000 and it was amended later in 2008. And there has been a recent amendment in 2021, which has sort of answered many of the queries that have bothered legal practitioners in this area from a long time. But you are essentially in a situation where you have to apply legal principles that were designed at a time when the technology was not at the level that it is currently, and applying those principles uh, to the new situations and the new technologies that come in sometimes becomes challenging. So one of the things that you have to live with as a technology lawyer, and particularly a lawyer who sort of deals with the issues in information technology law, is that there are going to be a lot of gray areas where there won't be any clear answers, and you would have to sort of communicate with the client, appraise them about these gray areas, and essentially ensure that they take an approach which is as per their business appetite and which leads to the least amount of regulatory risk. So with that, I think I'll just sort of go into the topic. So the first thing is that, as I was explaining earlier, this is an area which has picked up quite a lot. So historically speaking, there is a rise in the number of matters that you see either before courts or even in corporate practice about content takedown and removal requests that various entities receive. Uh, it's not very clear as to what is the reason for this, but I think one key reason that I feel is that there is a wide proliferation of internet within the country since 2014 at least. And because of that, because more people have access to the internet, more and more people are getting onboarded on these platforms which provide you services free of cost. And then, of course, they utilize your data for various purposes. So because there is a proliferation of these services and availability of easy data, more people are getting onboarded on these platforms, more people are using these platforms, and it appears that as more people are using this, people are also finding more creative ways of misusing the platform. And that is essentially leading to a situation where lawmakers and law enforcement personnel have to sort of contend with the possibility of preventing harm from being caused through internet services and through misuse of the services that are currently available, like search engines or websites or messaging apps, social media apps, etc., and essentially ensure that content that is harmful to people is essentially removed. So that is why the importance of laws relating to takedown is surging. So one of the and to give you a more statistical estimate of how things are in this particular sector, we have this Google Content Removal Transparency Report. So this report has been there. This report is, I think, published every year, and they publish the details of the number of content removal requests that Google receives across its services every 6 months. So it's a fairly updated thing. And they have been doing it from, as far as I know, from 2018 onwards. So what the report essentially points out is that the number of requests are rising. This year, between January to June, there have been 1,300 plus requests that Google received on all its services for content removal. And this is the second highest number of requests that Google received from the government across all countries. And this is only one service, mind you. So there are several other services that provide services similar to Google, or services that run a social media platform or a messaging platform. And by practice experience, those people also receive a fair bit of requests of content removal. In terms of who has been requesting takedown, police has been requesting the largest number of takedown requests as per Google's report. The second highest number is from the Ministry of Information and Ministry of Electronics and Information Technology. And as we will sort of go further into the topic, we'll try to understand whether the issuance of takedown requests by police is appropriate or not, because there is a certain procedure through which takedown is supposed to be processed, and it's not very clear whether a police officer can essentially on his own issue these kind of requests to people. So we'll take that up once we reach that particular topic. What is very surprising is that courts have been amongst the so courts can also issue requests for content takedown, and the number of requests that people have received from courts are quite low. So that came as a surprise to me also, because I have participated in several matters where people were requesting takedown of content, but ultimately it appears that the number of requests that finally go through these procedures to various entities, they are quite low. In terms of for what reason content takedown is requested, this is a very interesting sort of a thing. So the largest number of requests for content removal are received for defamation related matters. As you can see, in this period, it was 368. Nowadays, I think impersonation is also becoming a major issue. Impersonation is essentially a scenario where people utilize advanced technology and algorithms to create morphed videos of people, or have these deep fake kind of content on there, and then they circulate the content, and that creates a trouble. So impersonation has also been a major reason why content takedown is requested by people. There are obviously material which impacts national security and privacy, so those are also one of the reasons why takedown is requested. There is also an incidence of content which is obscene, or content which is religiously offensive, or which is essentially hate speech, and where the authority can come to you and ask for requests. So the reason why I sort of listed down these reasons is because when you sort of practice in this area as a lawyer, you will see that these are broadly the grounds on which you will receive these kind of content removal requests, and then you'll have to figure out, and it sort of helps to know that you can receive a takedown request about defamation. So then it would be helpful as a general matter to know the law relating to defamation, to understand whether that request is valid or not in the first place, and what should be the action that you should take. So this is the statistical backdrop to this topic. And now I will sort of come to the basic concepts, and let me just see if there's any question. So one question is who all can request takedown of content. So we will come to that. That is one of the areas which is quite contentious. So let's start thinking about how content takedown is structured, and like what should be the kind of questions that should come to your mind when you're thinking about these topics. So the first question that comes to your mind is, in what are the situations in which you can actually ask for removal of content? And this is one of the simpler answers to give. So as we all know that freedom of speech and expression is a fundamental right under Article 19(1)(a) of the Constitution. But unlike some other countries, the right of freedom of speech is not an unfettered right in India. It is restricted by Article 19(2) of the Constitution, which essentially says that state can impose certain reasonable restrictions on the exercise of that right. And there are certain parameters which are laid down within the constitutional framework of the grounds on which this right can be restricted. So the language, as you will see, is about so state can impose reasonable restrictions in the interest of sovereignty and integrity of India, security of state, friendly relations with foreign state, public order, decency or morality, or in relation to contempt of court, defamation, incitement to an offense. So these are broadly the grounds that exist for why, when freedom of speech can be restricted. And content takedown has an inherent link with freedom of speech, because ultimately, if you are asking for some content to be blocked, then you are essentially impacting somebody else's right to say that on a particular platform. So there is this balancing that authorities often have to contemplate about how to prevent excessive blocking of content on any particular platform, so that the freedom of speech is not affected in any manner. You will also come across, like in case you read more about this area, about this concept of a chilling effect. So when more and more requests of takedown are issued, and the platforms are imposed with a higher degree of liability to remove content, then there is often a possibility of the platforms taking proactive action to remove content on their platform which appears to them to be violative. And that often results in a domino effect uh, where essentially the platform preemptively blocks, so a large part of speech that could have been in the public domain gets restricted automatically. So that event is known as chilling effect. So that is one area which lawmakers and judiciary have tried to balance in the past while assessing laws relating to content takedown. So to answer that question in terms of in what situations can you request content takedown, first of all, content takedown can be in situations where there is a implication of the Article 19(2). So the restrictions that are written down here, those are definitely situations where you can seek removal of content. There are some other situations also. So if you notice here, uh, the element of intellectual property, violation of intellectual property of another doesn't come in Article 19(2). So the courts have also held that you can seek content removal if, let's say, somebody is violating your copyright and uploading some content on a website. Uh, and that's also one of the grounds that has been judicially recognized as being one of the grounds on which removal can be sought. Now, the second question is more interesting, where it's about identifying the person who's responsible for any violative content. And here, one of the things that has to be kept in mind is that there is a there is a legal difference when you talk about content which is in physical form versus content which is in digital form. So if you are a publisher of a book and you are sort of churning out hard copies of books every other day, uh, then if somebody so let's take the simple example where you are the publisher, you get an author to write a book, that author writes a book, and that book contains certain statements or certain material which is violative of, say, any of the laws on the basis of which, content can be like, which renders content offensive. So if the book contains some offensive language, for example, or the book contains certain statements which have some disparaging impact on some religion. So if that's a hardbound book and if it's a publisher, then legally the status of that publisher will is a little different from a person like who is running an internet platform and where this kind of a activity is taking place. So the point that I wanted to explain essentially was that there is a difference when it comes to things which are published in a physical form versus things that are published in an electronic form, and there are different liability thresholds that law prescribes for content which is on the internet. So if you take the physical case, if you are a content creator or if you are a publisher, then it is possible that uh, you would essentially be liable. So both people will be liable for publication of that material. Uh, in the internet scenario, there is a third category called intermediary, which we will discuss in detail in the next slide. But the essential point is that an intermediary is provided a legal defense against liability for any third party content that runs on its platform. And this intermediary liability is a major sort of a linchpin point for most social media platforms, where they really try to very strongly defend their status as an intermediary in various cases. So if you are a publisher publishing physical copies of books, if there is anything wrong in that books, then it is very likely that you will be implicated in the case and you will be treated as an abettor for publishing that content. But if you are an online platform, then the situation becomes a little gray, it becomes a little murky. If you are able to establish that you are an intermediary, then it is possible that you will not be held liable for the content which somebody else has put up and which may be violating of any particular laws that are there. There is also another aspect about content itself. So we like nowadays, I think everybody must have heard about original content, curated content, and user generated content. And these are three very distinct categories of uh, content that exist, and they are differently regulated. So original content is essentially if I am a singer and I make a video of me singing a song, then that is an original content that I have created. Uh, the other aspect is where I am uploading this content on a social media platform. So from the perspective of the social media platform, the content that I have uploaded is a user generated content, because that is by a user of that platform and not by the platform itself. If the platform, for example, creates some content, for example, if there is some Diwali advertisement that a platform has created and it is put up on its website, then that is an original content for that platform. But the content that I create will be always a user generated content in reference to that particular platform. And then there is also curated content. So there are various platforms which curate a lot of content. Curation is essentially a situation where various people where a platform sits down and essentially creates a portfolio of things that it wants to put. So your Netflix is a curated content platform where Netflix would have agreements with different film studios, and those people will provide their films and TV shows, etc., onto Netflix through some arrangements that take place between them. And ultimately, Netflix decides which content should be put on its platform or should not be put on its platform. So, as a Netflix, if on Netflix platform there is some movie which offends some religious sentiments, or if there is some obscene content on Netflix, then it needs to be examined whether Netflix will be liable as a publisher or whether it can take an intermediary defense. And most likely, it will not have the ability to take the defense as an intermediary. So these kind of concerns come up when you sort of discuss these issues with your clients, and that really makes and that really sometimes creates a lot of confusion in terms of what should be the legal response and solution to any particular scenario. Now, to answer one of the questions that had come in, so who all can request content takedown? And this is a very important question. So imagine a scenario where Google is, or where YouTube is a video platform where people can upload their own videos. Now, I don't like a particular video for whatever reason, and I tell Google that remove that video from the platform. It's possible that that video might be a copyrighted video that I own, and then I request Google that, please take down that video because I own a copyright to that video. That video might even have, for example, some obscene material or some material which offends my religious sensitivity, my religious sensibility. So I can ask Google to take down that content and remove that video. So now the question is that, if like if Google as a platform is supposed to decide which all things it should remove or not, then that is a fairly problematic situation, because ultimately the determination. So, for example, if it's a copyright infringement case, then whether Google is a competent authority to sort of determine whether a video that somebody wants to be removed from Google's platform violates copyright or not. Google is not a competent authority for that. We have courts for that, or we have some tribunals for that. But that kind of a legal determination cannot be made by Google. So the question in terms of who can request content takedown is a fairly problematic question, and there was a lot of litigation around this back in 2016 and a couple of years also after that. So can an affected party seek removal of content? Whether a public member, anybody who is interested, can seek removal of content. Courts can seek removal of content, or government authorities can seek removal of content. These kind of questions will come up when you sort of engage further with this topic. And the Supreme Court, in a very important decision called Shreya Singhal versus Union of India, it sort of touched upon this topic, where it essentially said that, if a platform like a Google is sort of required to sit in judgment for content that is to be removed from it, then that is not a very justifiable position to put Google in, because that is not the kind of determination that can be made by Google as a private party. There was also another case after that called MySpace versus Super Cassettes, where the court in fact noted that allowing private platforms to decide which content should be there or which content should not be there on them is also a very dangerous practice, because the experience usually suggests that bigger corporates tend to have a very risk averse approach when it comes to regulatory matters. So there is a possibility that, if they see that if they are made responsible for removal of certain content, then there is a possibility that they will overcorrect, and they will try to remove more and more content from their platform which meets certain parameters that they prescribe. So that also creates a scenario where, there is a possibility of a lot of content being deleted, a lot of content being blocked, and ultimately which leads to an impact on the freedom of speech and expression. So in that particular case, the Delhi High Court also sort of specifically recognized that private parties, when they sit in judgment over content, that can lead to a dangerous scenario where there could be a chilling effect on free speech. So this particular question as to who can seek takedown, I will take up in the coming slides, because it's a very tricky question to answer. In some cases, it's very clear who can seek removal. For certain types of matters, it's very clear that only courts and governments can order removal of that content. But then there have been exceptions which the court has created as well for these content types. And I'm just seeing some questions. Do
Yeah.
you think
Aditya, yeah, there are a couple of questions. Let's address.
yeah, so that's what. Yeah, so first question is, do you think the ever expanding strength of right-wing governments?
Before
Okay,
that,
yeah.
there is someone who's written a question on to us, the hosts and panelists. Abhishek, if you could just please post the question on the Q&A box so that everybody can see it. Only the hosts and the panelists can see the question that you've typed out on the chat box. Please put it on the Q&A box so that everyone can see it. Yes, sorry to interrupt, Aditya. Please.
Yeah, no problem. Okay, so he will, I think, put it there.
Yeah.
So, do you think the ever expanding strength of right-wing governments and the kind of control they want to have over popular culture, the request for takedown is getting more frequent? See, I wouldn't say that is the, I mean, I wouldn't comment on that point to be honest, but I would feel that it's a lot of the, so at least in practice, what I have seen, a lot of the requests for content removal that are received are actually genuine. And I think the underlying reason to that is probably the fact that, you know, there is a higher number of people who are using the internet. And because of that, uh, the possibility of misuse always increases. So yeah, so that might be the reason for why these requests are sort of expanding. Then another person has said, are the options of report abuse or similar options being misused to take down content? So actually, government has sort of, sorry, not government. So report abuse is actually a very sort of important development that many of these platforms have undertaken. And this has not been in response to laws in India, actually. This has been in response to laws in other countries which require them to sort of have these kind of mechanisms in place. But to be very honest, it is not very clear how effectively these options are utilized, even by those platforms. And I wouldn't know if, honestly, I wouldn't know whether they are being misused or not. That's a non-legal operational question. And does information technology decryption? Okay, so yeah, so decryption rules are different. Uh, so decryption rules essentially are about, so there are two aspects to illegal content that's there on the internet. One is about removing that content. The other is about trying to find out who uploaded that content in the first place. And that is where the interception monitoring and decryption rules come into play, where platforms can actually be asked to intercept content or to decrypt some information or to provide details of somebody who has sort of done that particular posting. So that's the context in which they are used. They are also used in various other contexts where the government wants to intercept certain data or get some information out of any social media or any of these platforms. So they are not used for blocking per se. Then the next question is, can social media platforms take down our posts if it isn't in accordance with policies? Wouldn't there be a chilling effect on our freedom of speech? So yeah, so that is another interesting area. So yeah, so social media platforms have their own internal policies for content uh, on them. And I think the most of the social media platforms that are popularly used are not India based. So their policies are fairly international, and they keep updating them based on developments in other countries. And in certain cases, for example, in context of grievance officer, etc., they have updated their policies even from an Indian perspective. So yeah, social media platforms can take down your content if it is not in accordance with their policies. The reason is that you are in a contractual arrangement with them. And the other point is that even the intermediary guidelines recognize the ability of social media platforms to remove content. And essentially, it flows from the contractual power that they have vis-a-vis you. There is a risk of chilling effect, and there has been quite a fair bit of debate about in what situations should social media platforms remove content or not remove content. So arguably there can be an effect on freedom of speech, but then ultimately the freedom has to be balanced with the ability of the social media platform to have a safe sort of an avenue where people can communicate with each other. Then the next question is, when takedown is passed by a court, what is the maximum duration the party can take for that? So I am not very clear what this question is.
Maybe this,
Person can probably clarify.
yeah, please reframe the question if that's possible.
Yeah.
Aditya, do you want to take the rest of the questions later in another interval, or like?
Yeah, maybe we can do that. Maybe we can do that.
Yes, we can carry on with the presentation for now. We'll
Okay,
come
sure,
to
sure.
these questions again in maybe another 15-20 minutes.
Yeah, we can do that.
don't worry, all your questions will be addressed. And as I said, there is some time allotted towards the end for a question answer. So please don't worry, your questions will be addressed.
Right.
Okay.
So now let's take on the next sort of question. So what can be removed in content takedown process? And that's also a very important question. And the importance is because, so first of all, it's not very clear as to what content means in the Indian law. Law usually uses the word information, which is a very, very widely defined terms, which includes everything under the sun that is processed through a computer resource. So sometimes a question arises when you are sort of involved in these kind of matters is that the client will come and ask you that, oh, I have got this request saying that if I don't remove this, they will block my entire website or my entire app. And particularly, there is a serious economic consequence involved in that kind of situation where a person's service itself is blocked off the internet. And you guys might be aware about there was this entire takedown that was done in respect of several apps last year for national security reasons. So these kind of things, and in fact, even before that, one very famous social media platform as it was back then was also blocked for a few days by an order of the Madras High Court. So in terms of what is the content that can be removed is also a fairly serious matter. Whether that content will just be a web page, whether it will just be a post, whether it will be somebody's account itself, because if you block a person off the platform, then that also has a major implication on that person's ability to speak on that platform. So if somebody posted one violative post, then if you remove his account, then that's a question that comes at whether that's a justifiable thing to do or not. And then of course you can, and the same applies for entire websites or apps where the implication is more economic on the people who are running that platform. So that's also a question where there is very limited clarity on currently, even under law. And the position seems to be that the law is broad enough to block any kind of content that's there. That can be a website, that can be an app. For user account, it's not entirely clear whether that is currently codified under law, but as a matter of practice, various platforms do block user accounts when they are found to be violating their content policies, etc. And now finally we come to moderation, which is also one of the topics that we'll be covering in this. And it's important to understand what is the difference between moderation and blocking. So moderation, so blocking is when some external person comes and tells you to take down some content. That is known as content takedown. That is driven by some legal process. Usually there'll be a executive authority or a judicial authority involved in forcing that takedown. And in certain situations, particularly copyright infringement, even the person who is affected by that infringement can be the counterparty in that case. Moderation is more of a proactive activity where a platform scans its repository of data and then tries to remove things which it feels are violative of various laws. And typically, because there are these because these things are the data sets that these platforms have are huge, and it's humanly impossible for any one person to sort of review that and find out whether it's proper or not. They usually use automated tools and AI to determine things that are violative, and then a certain subset of things are removed. So like, to give some perspective on the operational sides, uh, any con so and this is more of a slightly technical aspect of content takedown and in terms of how it works. So see, any content that is there on a computer resource, that content has something known as hash associated with it. So hash is essentially an alphanumeric set of characters which are associated to a particular piece of content, and that is unique to any content. So if I have a picture, then that picture can be hashed into an alphanumeric number, and that number will be unique to that copy of the picture. So if if somebody makes any modifications to that picture, or if let's say if I draw something over that picture using any of the paint tools or whatever, then that will change the hash of that picture, and then and then it will become a different picture altogether. So one of the mechanisms which many platforms use is essentially uh, to hash their entire content, whatever is there on their platform, and detect violative content based on that. So they will have, in the past, they will get to know that some pictures are violative because of their process, and then they will hash those pictures, and anybody who tries to upload the same picture again on their platform, that picture will get automatically blocked. So these are the kind of technologies that these people use to sort of prevent this content from being put up on their websites, and this is a mostly automated process. There are also human moderators which are sort of appointed by these people, mostly, and you might have read there are various articles on The Verge, etc., about how these moderation arrangements work. And usually the process of moderation is not carried out by the company itself; it is outsourced to a third party contractor, and usually the contractor is there in countries like India, where these kind of outsourcing services are available quite cheaply. So these human moderators have to comply with certain what as they are known as playbooks, which are guides in terms of how content moderation is to be undertaken. And they are shown content, and they have to determine whether or not that content is violative or not. So this is the moderation process that is followed. And up until recently, as late as February 2021, it was not entirely clear if moderation is a permissible activity under law, because, and we will discuss this more in the context of intermediary, but the concern is that if a platform is actively taking steps to remove content from its databases, then whether or not it can be demonstrated that that platform is actually aware about the content that is there on its platform. So the implication of that is that if it's a so if you want to claim the status of an intermediary, the position is that you have to be blind to the content. You are just a conduit through on whom or through whom the content passes, or on which the content exists. But you don't know anything beyond that about that content. But if you are moderating content actively, then argument can be taken that you are aware of what content is there on your platform. So your position becomes similar to the publisher of a magazine on which some defamatory article is published, because that person is then aware about that content, and then you should ideally be prosecuted for this entire moderation activity. So the position of law was in India was fairly unclear about whether or not moderation is permissible, and we would receive a lot of queries on that. But essentially, now the position has sort of been cleared by the recent intermediary guidelines that have come in, and which sort of legitimize the activity of moderation. In the past, courts were sort of encouraging the moderation activity, because uh, the policymakers in India realized that they do not have the mechanisms to moderate content on their own, and content blocking as a procedure cannot always be the default by which illegal content is removed. You also need some proactive measures which can be taken by that platform to get rid of some illegal content. So that has been the development of law around this area. And I think now, before I go to the next slide, which is the legal framework, I will just take up the questions, because there seem to be a lot.
Yes.
I don't know if this is the okay. This is the Q&A. There seems to be a lot of things on the chat also. So
Yeah, the
I
chat
don't
box.
know.
So someone has posted one question on the chat box. I think, I mean, it's specifically for the hosts and panelists. So I would really request the person to post it on the Q&A box so that everybody can see it. I mean, I can't copy paste it myself. Otherwise, I would. Ansi Jacob, please put the question on the Q&A box instead of on the chat box so that everybody can see it. And there are some requests to get access to the webinar PPT. Unfortunately, that cannot be shared. But We will definitely be sharing the recording of this webinar. You just have to stay tuned till the end of this webinar to receive the recording. And see, please put it on the Q&A box, not on the chat box. So it will just be easier for us to sort of keep a track of your question. Then otherwise it will get lost in the chat box. Please put it on the Q&A box. Okay.
Yeah, sure. So I think the first question is the one where we were not clear as to what it means.
So we can
So
leave
we
that
can
for
leave
a
that
while.
one.
Yeah.
Then the next question is, what's the difference in implication on OTT platform in comparison with other platforms? So yeah, so the difference is very clear. So first of all, OTT is a very wide term. OTT essentially means over the top, and the idea is that the entire technology architecture that powers our internet and telecommunication, etc., is in various layers. And so there is a telecommunication layer which exists, on which your phones and uh, other things sort of work. And then there is a data layer on top of it. So any platform which runs on the data layer of the uh, information technology infrastructure, as it is called, that is known as an OTT platform. The implication of takedown laws will essentially, so it's very simple actually. So if it's a intermediary which you are talking about, then an intermediary has certain requirements to remove content. If it does not remove content, then it is liable as an abettor and can be punished for that content. And we'll come to in terms of how that happens, but essentially that's the implication for intermediaries of not complying with law. And for other people, if Netflix has some content on it which is violative, then if a takedown order is issued to Netflix, then violation of that takedown order can result in because it's a criminal offense to not comply with such takedown order. And there is also a possibility for Netflix to be liable in the first instance for that content. So usually in practice, we see that authorities are content with just ensuring that something is removed and not going beyond that to take extra steps to punish that platform unless there is a serious non-compliance by that platform of various activities. Okay, so the next question is, can guidelines which are issued by government which regulate the functioning of social media platform be considered arbitrary? Can intermediary guidelines put a compulsion on social media to abide by these rules? Okay, I mean, of course, like the guidelines can, so the recent guidelines that were issued, they have been challenged as arbitrary in various cases. And uh, a part of that guidelines, which relates to digital media, is kind of stayed. I would use the word unconstitutional rather than arbitrary, because arbitrary is a component of unconstitutionality. Arbitrariness is something on which you decide the unconstitutionality of something. But yeah, they can be challenged as unconstitutional. Whether they can be considered arbitrary or not is a question which requires a more longer session and probably a higher amount of time. But there are certain elements in the guidelines which are questionable, and uh, definitely they are. I mean, those issues have been sort of raised in these cases about the guidelines being arbitrary in that sense. So yeah, they possibly can be. There are various aspects about. I would say one aspect is about this entire this requirement of identifying the originator of content that has been challenged as arbitrary. There is also one major thing about whether a guideline like the intermediary guideline can in fact even be issued under section 79, because that sort of goes beyond the remit of the provision itself. So that's also another issue that arises, that is more from a legislative competence perspective, that they have been challenged. So next question is, can the posts of influential person and a normal person be treated similarly? Okay, I don't know the answer to this, but uh, typically I wouldn't know, but I would feel that there might be a higher threshold that you could probably ascribe to somebody who's influential, because that person's post would have a wider reach, and you would want to take action against any violative post that the person has put on a platform in a much faster manner as compared to a normal user. And in fact, that's something that's observed. uh, Platforms are usually more proactive on actioning posts by influential people. Whether or not they take it down is a different matter altogether, but they are more proactive about trying to develop response to a legal response to those kind of posts which are put up by influential people, because there is definitely a risk of a greater harm being caused to the public, because that post will probably be visible to more people than any normal person. What is your view on Advocate Sanjay Hegde's case against Twitter? Is Twitter serving a public function, as the petitioner has stated? So first point is about public function, and that's a usual argument. That is a argument that people do take, and the idea, and just to give a context to this, so usually fundamental rights cannot be enforced against private entities; they are available against the state. And there are certain fundamental rights which are also available against private actors, which basically relate to uh, violation of violation of laws relating to caste discrimination, etc. Uh, so there are these three clauses in the three provisions of the Constitution which can be uh, enforced against people, but most everything else is enforceable against the state. And then, of course, there is the entire debate about what is the state in the constitutional context, and that is where the concept of public function comes into picture, where it has been said that any entity which performs a public function, that is a function that the state should ideally perform, that entity can be proceeded against, because, so like another example could be a stock exchange, for example. So a stock exchange has also been held to perform a public function, if I'm not wrong. So whether Twitter can be done, it's kind of unclear. I don't know what would be the position on that particular matter. Maybe, I don't know. But I mean, if you implicate Twitter, then you would also have to implicate a lot of other social media platforms for the same reason, for their wider reach. And that would add a layer of additional litigation that these platforms would have to face generally. So then the next question is, recently Meteor introduced the IT rules and there was much resistance. First originator, how can we draw a line between security and privacy, because IT rules are quite vague in this respect? So that's a very valid question. In fact, I would say that when you talk about the first originator provisions, uh, I mean, they are not at all clear about who or in what mechanism should the first originator be determined, because it's essentially saying that the platform will just provide that this is the first originator, but whether there is any quality standard or whether there are any standards that are required to be maintained by the platform while identifying the person who first originated some information, there is no clarity on that. So yeah, it's a provision where there is a definite cause of resistance. The other issue, and it's a balancing matter essentially, and that's something that I see a lot of questions have put in, and there are no clear answers to that, which is why I sort of started the PPT with the idea that there'll be a lot of gray areas when you sort of start working in this sector, because yeah, you will have to balance the security interest and the privacy interest both, and the way to balance it is something that is a very difficult determination to make. Usually that determination happens in a very case to case basis, where you would, for a particular situation, determine that in this case probably the privacy interest has to give away, or in this case the privacy interest has to reign supreme. So it's a very subjective determination that happens in these matters, and there's no clear way to draw a line. You'll have to go and figure out from a case to case basis only. Yeah, so I think the next one is something that we discussed. to bring it under writ jurisdiction. Okay, so the next question is deploy technology-based measure for proactive monitoring. Whether content can be removed. Yeah, it can be removed in case of copyright infringement. I don't understand what is the implication of that on the right to privacy, but definitely it can be removed. And in fact, there is a lower standard of removal of content that is there when it comes to content infringing copyright. So the procedure is simpler, and you can go sort of further. I mean, you can basically request uh, content removal in a much easier way than any other type of content. Maybe the second part of the question relates to the first. Technology-based measures for proactive monitoring. Can you discuss the implication of the same on right to privacy? So I would say that those measures are already implemented. Uh, as far as my understanding goes on those measures, uh, proactive. So one thing to understand is that proactive monitoring is a very vague expression. Proactive monitoring essentially means monitoring your platform for content that is violative. And if that is the understanding, then that is already being done. And that has been upheld by the courts also in various cases. In fact, there was this matter called Prajwala versus Union of India, where there are various orders of the court where they have, in fact, they have created this standard operating procedure for removal of content relating to child porn and rape material, etc., which is there on various platforms. And there they have recognized the importance of proactive monitoring measures. So, like I said, it's again a balancing aspect. Uh, the implication and probably in a situation where it's a technology based measure without any human intervention, I would say that that sort of is quite effective in removing content, especially when you're talking about the scale that the information is growing in today's time. Please share some insight on right to forget and current situation of takedown laws. So right to forget, I think, is a topic which would not be covered by today's seminar, but that is part of the data protection bill that recently came out. That doesn't have so that cannot be used for, that's not exactly content removal, that's something else entirely. And the current situation of takedown laws we are discussing. So maybe at the end of the presentation, you will have a better understanding of that.
Okay, I think that's quite a lot of questions that have been covered. That's great,
Yeah,
Aditya.
yeah. So I thought maybe before we go to the legal framework, I'll just sort of get done with the questions
Yeah,
here
that's
then. Yeah. Okay, so now I'll sort of try to quickly cover the legal framework. So when you look at the framework for content removal, you have to look at two different types of laws. The first type of law is which tells you what is the content that is illegal. And that is an important thing because, and that is different from the law which provides you the process for removal of content. So there are these two different types of laws that have to be kept into mind. So if somebody comes to you saying that this, I have received this request to remove this type of content. So the first thing to check is that, whether that content is illegal under any particular law or not. Because if it is not, then probably at a first level only you can tell them that probably this request is not a valid one, and you can respond back in kind. Some examples of these kind of laws are Indian Penal Code. Towards the end, I think around the 200s sections, you will find various provisions there which talk about content which is illegal. They talk about it in not so much of a digital context, but those those provisions are in fact applied in practice even today for even content that is there on the internet. So you have content like seditious content or content, uh, I mean, content which is against any particular religion or affects the sensibility of any particular group. So that kind of content is covered under the IPC, and that's where those are the kind of provisions which are put in the notice that you get for removal by the authorities. The Information Technology Act has a lot of provisions about specific kinds of content which is illegal. So, for example, content which has child porn in it, or content which is obscene, which has been developed without the permission of the person, those kind of content is illegal. And we'll actually come to the rules part in the next slide. There are also a lot of other statutes which you can consider while thinking about this area. So one old statute is this Indecent Representation of Women Prohibition Act, where also you will see that there are multiple provisions about specific types of content being classified as illegal under law, similar with Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act. The prenatal conception, the PCPNDT Act is also quite interesting, because this talks about advertisements for gender determination at the time of birth, and those are outlawed. And in fact, there have been cases in the Supreme Court. In fact, I think it's a three-judge bench case where they have sort of discussed this particular act in the context of content removal. So even this is another law that you can take a look at. And of course, there are intellectual property laws, particularly the cases you see in Copyright, Trademarks and Designs Acts, under which cases for removal come. And these kind of cases usually go before judicial authorities, where they are filed in the form of civil suits before high courts. And they're essentially the way the case in terms of IPR violation works is that along with the person who's violating the IPR, the platform on which that illegal violative content appears, that is also made a party to that case, and then the court might pass an order for removal of certain types of content. So if there is a, for example, if you see there is a website which is showing you photos of different brands, but it doesn't seem to be a very legitimate website, then that can be an instance of copyright violation, and you might be and there actually might be a case going on against that website. So one example is this website called Darby's, which was there, I think, back, and that the idea of that website was to have a lot of these very expensive luxury products, Gucci and all that, and they would sort of put up photos of those products and try to sell them, and then also sell counterfeit products. So there was a violation claim under that, and even that website was ordered to be taken down by the High Court in one case. So this is the first kind of law, the law which determines what content is violative. And there can be many more laws than that, many more laws than what is listed here. This is just a few examples. Another very good place to sort of have a consolidated understanding of what is not permitted on an internet platform is the intermediary guidelines. And so you will see that it essentially lists down the kinds of content which are not allowed on platforms. So you will have content like things which belong to other people, things which are defamatory, obscene, pornographic, invasive of bodily privacy, racially or ethnically objectionable, relating to money laundering, gambling, etc., content harmful to children, content which impersonates other people. You'll also see a category of content like computer virus or other things which are intended to destroy information on a computer resource. So these are the kind of content which is typically recognized as being a violative content in law. And if you are evaluating the permissibility of a takedown request in any context, then the first evaluation that you have to do is to see whether what exactly is the type of content that they are trying to ask, they are asking you to remove, and whether that content is permissible under the law or not. So that is one. Now the other aspect is about the law that provide the procedure for content takedown, and this is where it gets a little interesting. So before I take up the law which provides the procedure for content takedown, I think we can discuss the concept of intermediary first, and about the safe harbor provision. So as we also discussed in a few slides before, intermediary is essentially a person who is a conduit, a person who acts on another person's behalf and basically receives or transmits certain information. So this definition that is copy pasted here, this is the definition of intermediary under the IT Act. It says that intermediary is any person who on behalf of another person, so this on behalf of is a very important expression in this definition, receives, stores or transmits any electronic record or provides any service with respect to any particular electronic record. So this is the concept of an intermediary, somebody who receives, stores or transmits electronic record on behalf of another person or provides any service with respect to electronic record. So to break it down in terms of examples, if let's say if you have a Facebook and on that you are uploading a video, then that is a third party electronic record which you have uploaded, and Facebook is allowing you a place to transmit that electronic record. It is also allowing you it is also providing you a service in respect of that electronic record, which is essentially displaying it to the public. So Facebook in that context could be an intermediary in a particular scenario. So that's the kind of determination that you make. And if you go to the second part of this definition, then the second part of this definition identifies certain people who are intermediaries, who are recognized as intermediaries under law. So one good example to understand the concept of intermediary is a telecom service provider. So a telecom service provider is essentially somebody who provides telecommunications connectivity. So any content that goes on that on a TSP's network, the TSP is generally not aware about it. And that is one argument that is taken often in case there is a case where a TSP is also implicated for violation of any particular content law. The TSP simply says that I am an intermediary, I am a conduit through whom the transmission takes place. I am not aware about what is the content that's there. Similarly, for network service providers and internet service providers, though there is an argument to be made that often internet service providers are aware about what is happening on their platforms, and there are ways to prevent them from knowing that. But that argument, it's a recognized term in the law, so it ultimately becomes a fact-finding determination whether in a particular situation or not a TSP or an ISP was aware about some content being there on its platform. Another interesting point of this definition is an online marketplace. So you would think that your Amazon, for example, can take a what do you say, a defense as an intermediary about any content that is there on its website. And I wouldn't cover it in this session, but essentially an online marketplace typically sells products which are real world things. So Amazon would, for example, sell you the latest phone that you like, but whether or not that can be covered within a content law framework is a questionable thing. There are platforms which also which also sell content. So I think you might have been aware about this case called Avnish Bajaj, which was a long case, which was long ago, and which in fact led to the development of this concept of intermediary. So essentially, the platform in that case, if I'm not wrong, was eBay, and eBay was essentially and somebody was selling a pornographic clip on eBay. So in that context, this content law sort of came into picture. But in case of online marketplaces, it needs to be analyzed whether a particular law applies or not. So that is the concept of intermediary. But now, what is the reason why this concept is introduced? And the reason is that there is a aspect of special legal protection that is granted to intermediaries. And that special legal protection is covered under Section 79 of the IT Act, where, and I'll just scroll to that section just for ease of reference. So if you see the section, it says exemption from liability of intermediary in certain cases. So what it essentially says is that an intermediary shall not be liable for any third-party information, data, or communication link made available or hosted by him. So this is a legal protection that is there to intermediary and to these kind of platforms, where essentially any third-party material on their platform, they are not liable for it. But then that's not an unqualified sort of protection. There are various conditions which are set out in the section itself, which identify in what scenarios can an intermediary claim this kind of a liability exemption. And one of the important ones, and I haven't touched upon the conditions in the second subclause, but one of the important ones is under subsection 3, where it talks about where it talks about an intermediary actually removing content upon the receipt of actual knowledge. And there is also another sub-provision which talks about the intermediary complying with any due diligence requirements that are prescribed under law for that intermediary to perform. So these are essentially the conditions on which this liability exemption is provided. And we can discuss it in more detail in terms of how this works in practice. Then you have, of course, the blocking procedure, which is there under section 69A of the IT Act. And the way I see it, this is the court-approved process of content blocking that exists in India. There are procedures of blocking which are prescribed under the intermediaries guidelines, which are there, which have been sort of created under the section 79 itself. But whether or not those procedures are valid is a questionable aspect, because the law has already prescribed a particular way of doing something, and then to have a less stringent way of doing that through another provision, that becomes somewhat of a legal problem. So if you remember in the beginning, I had mentioned that police often issues takedown requests. So if you look at the procedure that is there under section 69A of the IT Act, then police can never issue a request for content takedown. That request has to be issued by a high level officer in the central government Ministry of Information, Ministry of Electronics and Information Technology, by some, in fact, by the secretary of that government department. But we see in practice that police officers also issue requests, and those requests are typically issued under section 79, subclause 3, which is this. And whether or not those requests are legally tenable or not is not a question that has been sort of deliberated upon in detail by courts. And in many of the petitions that have been, in fact, filed for challenging the new intermediaries guidelines, I think one of the challenges is this also, that there is a parallel content takedown procedure that is there under that law. And that procedure is probably not valid, because there is an alternate robust procedure under section 69A. So that is a development that will probably get decided once those cases come up for hearing. But yeah, you will in practice see many requests under section 79 subclause 3 also for content removal. In terms of how lawyers typically advise platforms, while you would obviously say that, that this is not the correct section to issue that request, and an argument can be taken that that request is not valid. In practice, platforms often comply with such requests to prevent any legal blowback. So that's the reality, the way it exists. In terms of the procedure of blocking, I'll very quickly take you through this. So as I was mentioning that blocking under section 69A, which is actually this provision. So if you see, it's a very narrowly drawn provision. It says that where central government or its officers or any of its officers specially authorized by it, then there are certain criteria on which blocking can be requested. So it's only in the interest of sovereignty and integrity of India, defense of India, security of state-friendly relations, preventing incitement to the commission of any cognizable offense. So these are essentially the reasonable restrictions under Article 19(2). So blocking can only be in respect of content which can be restricted pursuant to Article 19(2) by officers who are specially authorized by the government in this behalf. And when you are essentially subjecting some information to blocking, then you also have to, I think, provide a hearing to the person whose content or on whose platform that content exists, which you want to block. So there are certain safeguards that are provided, and non-compliance with this provision is also a criminal offense. So that's why it has a deterrent effect. In terms of the procedure of blocking that is provided under the blocking rules, as they are called in parlance, in the regular parlance of practice. And essentially the blocking procedure is that the government appoints an officer known as designated officer. Each government department in states or in union territories or at central level, and even in certain notified agencies, has an officer called a nodal officer. If I want to get any content blocked, then I can send a complaint to such nodal officer. That nodal officer has to examine the content, examine the complaint to see whether the requirements of 69A are met or not, and then transmit that complaint to the designated officer at the central level. The designated officer then has to conduct a hearing to see whether, like, what is the reason for that content being there and whether or not it should be blocked. Then this entire complaint is referred by the designated officer to a committee which consists of fairly senior members from Ministry of Law and Justice, Home Affairs, MIB, certain, etc. Not below the rank of Joint Secretary. So these are like top level people. And then the committee examines whether that complaint is valid or not, and whether it's justifiable to block all this or not. Then finally, after the committee makes some recommendation, the designated officer sort of forwards that recommendation to the secretary of MITI. And then upon approval of the secretary, that complaint can be processed and the content can be blocked. You would have noticed, in case you are following up on this entire thing, that a lot of Chinese apps, close to I think 200, were blocked last year. And the procedure that was followed for blocking of those apps is under Section 69A only. They utilized an emergency power that exists under Section 69A, where the rigor of this process can be circumvented for a particular period of time, where an interim block-in order can be issued. And then the procedure has to be followed to make that order permanent. So that is how that entire sort of thing played out. So in terms of the takedown process, I think this is what is there. There are certain specific takedown requirements which are there under the intermediaries guidelines, which are fairly new and which I am not discussing right now for the paucity of time, and also because they are all under challenge. So one doesn't know whether they will remain or not. So that is for the legal framework. So maybe if there are any questions, we can take them.
We'll take the questions in a bit. I would request everyone to sort of just put the questions in the Q&A box if they have any. But like, there is definitely something that I wanted to bring to the notice of all our attendees today. And since there we have a paucity of time, and since there is quite a lot to cover because this is such an interesting and intense topic, we have a bit of a surprise for our attendees. Aditya, I would like to share my screen if that's all right.
Yeah. Please go ahead. I'll stop
So
sharing.
yes. So Lawctopus Law School, as some of you might be aware or may not be aware, we are organizing a course on TMT, where these topics will be covered in a lot more detail than in this webinar. And our faculty, is my screen visible to everyone? Please write in the chat box if it is. So
Yeah, I can see it.
great. So our Lawctopus Law School is organizing a course on TMT laws, and this course will be really intensive and a very comprehensive course about TMT, and it will have everything that you need to know about TMT laws. It will cover all aspects about telecom laws, about new technologies, emerging technologies, as well as media and entertainment laws. And it is a very interesting field. It has a lot of career prospects because it's, this is the digital age. There's a lot to do in the world today with when it comes to technology. It's booming across every sector, so it has applications everywhere. And there is a lot of development going on. There is a lot of flux going on in TMT. There is so much happening, and it's really exciting. Every day in the news we see some or the other interesting thing about TMT. So we have a course on TMT which will make you aware of whatever is happening and will give you all the basic and the fundamental knowledge to sort of understand TMT. And it will help you become a TMT lawyer, and it will give you the skills that will be helpful in becoming a TMT lawyer actually. So you should definitely check out this course because it will help you in a lot of ways. The topics that you will be taught in this course are the different legislations in this domain. Like I mentioned, you will be learning about fintech regulations and cryptocurrencies. You will be learning about privacy, data protection, e-commerce, liability of intermediaries, and content moderation, like we discussed in the webinar today. Aditya did a great job of, sort of introducing us to what content moderation and intermediary liability is. But there are detailed modules in this course which will talk more about, which will build on, cover more in depth into what has been covered in this webinar. You will learn about telecom regulations, media and entertainment laws. You will learn about emerging technologies like drones, AR, VR, blockchain, IoT, 5G, augmented reality, so many things that are you see in the news these days, and you would want to know about them, and you want to know the law behind what are the laws regulating them. So all of that will be covered in this course, and this is a one of a kind course because no other course in India covers all these new developments and details in such great detail and in a learner friendly manner. So as you all must be aware, Lawctopus courses are mostly online. So this is going to be another online course, which will be completely self-paced. You can do it from the comfort at your house, and there'll be experts like Aditya. He will be taking the live sessions for most of these. We also have an expert for blockchain coming in, so you will be learning a lot about cryptocurrency as well, which is something that's really new and upcoming. You will learn about NFTs and so many things that you see in the news these days, and you want to learn about them. So you learn a lot in this course. There are modules which have reading resources basically, which will give you all the information you need about these areas. And these modules have been prepared by people who have worked in law firms like Nishit Desai Associates, Trilegal, Amarchand, and Khaitan. And you will learn so much more once your learning will be like supplemented once reading these modules properly. And there'll be assignments which will test your practical skills. They will test your knowledge and advisory skills about whatever you've learned in these modules. It will be tested by these assignments. And there'll also be an online forum provided by Lawctopus where you can discuss and resolve your doubts. You can connect with your peers there, you can network there. So it's a great opportunity for interacting with your fellow professionals and fellow students. And since it's a Lawctopus course, we promise a really warm and caring learning experience for all of you. And we will give you all the support you need to do well in this course. And just to sort of recap about the benefits, it is completely self-paced. You will save time by doing it. It's a 2-month course. You can do it at your own pace and time. You will get a certificate of completion. And the top learners also receive a letter of recommendation, which you can share on your LinkedIn, and you can put it on your CV. That'll look great to have this sort of achievement on your CV because this course has been prepared by experts. So if you are interested, please do check out this course. I've put the website link here. And as I said, there was a surprise for people sticking around till the end. Since the course is being launched on 20th of January, for all those who attended this webinar today, there is a 15% waiver for all of you. If you use the coupon code TMT15, you will get a 15% waiver on registering for this course. So you will get it at a great price. You will get all these materials at a great price. And it's a once in a lifetime opportunity, and you should definitely take that up. If you have any questions, you can contact our counselor Snigdha Ghatak. Her number is given on the screen. So please do check out this course. I will put the link of this course, and I will put the link of this course on the chat box. And thank you so much for coming to the webinar, and thank you so much for taking the time out to listen. So I'll just sort of get back to Aditya and ask you all if you have any questions. So
Yeah, I think maybe we can just take up the questions now. I think there's a shortage of time. We have overshotted by half an hour. So if there are any questions, we can just take them up. Otherwise, we can conclude. Maybe I'll just add one bit from a practicing person's side about this course, and I think it's quite unique.
Sure.
So I mean, see, I haven't come across a very decent textbook on TMT laws so far in my practice of like whatever 4 or 5 years. I don't think there is a book that exists, and probably what Lawctopus is trying to do here is quite important because when you join as a TMT lawyer, it's always better to have a detailed understanding beforehand, because you work on very short time frames. You have to understand a lot of new technology, and then it becomes quite challenging. It was quite challenging for me, and it's very challenging to find good sources of accurate, updated information in this sector. So yeah, I mean, I would say that it will be a great opportunity for people who do it probably, I guess.
Thank you, Aditya, for the kind words. That means a lot. And if a practitioner is saying that, this was something that was helpful and relevant for him, so I
I
really
would,
hope.
I would, I would, I have seen the initial drafts of the modules, and I think they are very helpful. So I would really say that people can use them. So
Thank you so much, Aditya. That was really nice of you. And I would really request you all to definitely consider this course and check it out if you find it. If you found this webinar valuable, I'm sure the course will also be something that you'll find really valuable. Aditya is also one of our faculty for the course. Thank you so much for taking the time out in this evening. And it's a Saturday evening. I'm sure all of you must have had some plans or the other in some way. But thank you so much for coming, and thank you so much for taking the time out to devote to your learning. It was great having you all here, and all your questions. They were really intelligent and they were really insightful. And I'm sure Aditya had a great time answering them and,
yeah, yeah,
being
yeah.
there for you.
They were quite insightful, I would say. Like, I mean, especially if people from first, second year are asking these kind of questions, then it's kind of in the right direction, probably.
That's great. And that's kudos to all of you. And thanks so much for being, supporting Lawctopus and coming. And please share your feedback with us. Please check out the course. Have a great evening. We'll stay in touch with the WhatsApp group. Thank you so much again, Aditya, for taking the time out. And
Thank
thanks
you. My
for
pleasure.
enlightening our learners with the information. I'm sorry there's no participation certificate for this. The gift that you receive is the information from the session. So thank you all. And I think I'll end the session now.
Thank you.
Thank you.